On January 30th, the Department of Justice dropped over 3 million pages of documents, 2,000 videos, 180,000 images, all connected to Jeffrey Epstein. And within hours, photographs surfaced showing a man who appears to be former Prince Andrew kneeling over a woman on the floor. But here's the thing, the photos are the headline. They're not the story. The real story is buried in what the DOJ didn't release. And from a prosecutor's perspective, that's where you need to pay attention, because right now, the most powerful justice system on the planet just told Congress it has fully complied with the law, and Congress is already pushing back because the math doesn't add up. Pay attention to this next part. Let me lay out the timeline because context is everything here. Back in 2005, the Palm Beach Police Department launched a 13-month undercover investigation into Jeffrey Epstein after a parent reported that he had sexually abused their 14-year-old daughter. By the time that investigation wrapped up, police had identified dozens of victims, girls as young as 13. The case was referred to federal prosecutors, specifically to the U.S. Attorney's Office for the Southern District of Florida. At that time, that office was run by a man named Alex Ayosta. Now, Ayosta's prosecutors built what should have been a devastating federal case. A 60-count indictment was drafted. 30 victims had been identified. The FBI was still actively investigating, and then Ayosta shut it down. In 2007, his office entered into what has now been universally referred to as a sweetheart deal, a non-prosecution agreement. Epstein would plead guilty not to federal sex trafficking charges, but to 2 state-level prostitution charges in Palm Beach County. He served 13 months on work release, allowed to leave the jail up to 12 hours a day, 7 days a week. Think about that. A man accused of sexually abusing dozens of girls, some as young as 13, serving 13 months, mostly outside of prison. And here's what made it worse. That deal immunized Epstein's co-conspirators. It concealed the terms of the agreement from the victims, and it effectively shut down the federal investigation. A federal judge later ruled that this violated the Crime Victims' Rights Act. The DOJ's own Office of Professional Responsibility concluded Ayosta exercised poor judgment, but no one was held criminally accountable. Now, fast forward. In July 2019, federal prosecutors in the Southern District of New York, Jeffrey Berman's office, brought new sex trafficking charges against Epstein. This time they were going for the full force of federal law, up to 45 years in prison. 6 weeks later, on August 10th, 2019, Epstein was found dead in his jail cell. The official ruling suicide, and the federal investigation, at least as a prosecution, stopped. But here's what people forget. When Berman announced Epstein's death, he said this: "The investigation into the conspiracy caught the broader network remains ongoing." That word conspiracy is not accidental. That's prosecutorial language. That means they were looking at other people. Now we get to January 30th, 2026. The Epstein Files Transparency Act was passed by Congress in November 2025 with near unanimous bipartisan support. It required the DOJ to release all federal documents connected to Epstein and Ghislaine Maxwell within 30 days. The DOJ missed that deadline. They said the volume of material, 6 million pages, required more time to review and redact victim information. On January 30th, Deputy Attorney General Todd Blanche held a press conference. He announced the release of over 3 million pages, 2,000 videos, and 180,000 images. He said, and I'm paraphrasing his exact words, that this release marks the end of the process, that the DOJ has fully complied with the law. Here's what they're not telling you. The DOJ identified 6 million potentially responsive pages. They released approximately 3.5 million after redactions. That means roughly half of the documents were withheld. Now Blanche offered several justifications: victim privacy, child sexual abuse material, ongoing investigations, attorney-client privilege. Those are legitimate legal categories. I'm not disputing that. But here's where it gets dangerous. The House Oversight Committee, led by Democrats, sent a letter the very next day. They pointed out that the DOJ itself identified over 6 million responsive pages, released only about half, and then claimed full compliance with the law that said release all unclassified records. Rapure Robert Garcia, the ranking member on that committee, was direct. He said the DOJ is withholding roughly 50% of the Epstein files while claiming to have fully complied with the law. He called it outrageous, and Reppers Ro Khanna, one of the actual authors of the Transparency Act, said the same thing. He said the failure to release these files only shields the powerful individuals who were involved. Now, from a prosecutor's perspective, here's why this matters. When you have a law that says release everything and the executive branch releases half and says we're done, that is not compliance. That is a negotiation. And the question every prosecutor should be asking is what's in the other half? Let's talk about what was released, because even what they put out is explosive. The Prince Andrew photographs. 3 images showing a man who appears to be Andrew Mountbatten Windsor, now formerly Prince Andrew, kneeling over an unidentified woman on the floor. Her face is redacted by the DOJ. In one photo, he's looking directly at the camera. In the others, his hand is on her abdomen. No caption, no date, no location. The DOJ provided 0 context. And accompanying those photos, emails, an account labeled the Duke exchanging messages with Epstein. In one August 2010 exchange, just months after Epstein was released from home detention under that sweetheart deal, Epstein offers to introduce to a 26-year-old Russian woman for dinner in London. The response would be delighted to see her. And then, will she be bringing a message from you? Please give her my contact details. In a separate September 2010 exchange, the same account suggests dinner at Buckingham Palace and adds the phrase, lots of privacy. Now, Mountbatten Windsor has repeatedly denied any wrongdoing. He settled Virginia's lawsuit for an undisclosed sum without admitting liability. And King Charles stripped him of his royal titles just months ago in an attempt to distance the monarchy. But the legal question here isn't just about Andrew. It's about the pattern.
The files also reference Commerce Secretary Howard Lutnick planning a visit to Epstein's private island in 2012. Email correspondence between Epstein and Elon Musk. References to filmmaker Brett Ratner, Sweden's Princess Sofia, Denmark's King Frederick, Norway's Crown Princess Mette-Marit, whose name appears hundreds of times in the released material, and among the released documents, an internal FBI document from August 2019, just 5 days after Epstein's death. It lists 9 persons identified as family and associates of Epstein. 8 of them are labeled co-conspirators. Most of their names and faces are still redacted. 8 co-conspirators. Only Ghislaine Maxwell has ever been charged. Pay attention to that number. 8. And remember, Aosta's 2007 deal immunized co-conspirators. Maxwell was convicted in 2021. The Supreme Court declined to hear her appeal in October 2024. Her conviction stands, but 7 others at minimum have never been charged with anything.
This is bigger than one case. This is a systemic failure across multiple administrations, multiple prosecutors, and multiple institutions. So what happens now from a legal standpoint? The Oversight Committee has issued a subpoena to Attorney General Pam Bondi demanding the full unredacted files. That subpoena has not been fulfilled. Senate Minority Leader Chuck Schumer has asked pointed questions publicly, including whether every document mentioning the word Trump has been released and whether all co-conspirator memos have been disclosed. Deputy AG Blanche pushed back on the suggestion that the DOJ protected anyone. He said there was no White House oversight of what the material showed. He said if evidence exists that others abused victims, the DOJ would pursue charges. But here's the problem with that statement. The DOJ said it would pursue charges, but it's also withholding half the documents. You can't make that promise credibly while simultaneously sitting on millions of pages. And from a broader institutional perspective, this raises a question that should concern every American regardless of party. We had a federal prosecutor in 2007 who had the evidence to bring a major sex trafficking case. He didn't. He gave Epstein a deal that protected co-conspirators and silenced victims. Then in 2019, a new prosecutor brought the case and the defendant died before trial. Now in 2026, Congress passed a transparency law with overwhelming bipartisan support, and the executive branch is claiming compliance while withholding half the responsive material. At every single turn, the powerful have been insulated from accountability. The victims have not. Virginia, who brought lawsuits that forced much of this into public view, died in April 2025. She never saw a single person other than Maxwell held criminally accountable for what was done to her and to dozens of other young women. This is what institutional failure looks like. It doesn't happen all at once. It happens incrementally, deal by deal. redaction by redaction, deadline by deadline. And the question right now, the question that should keep every prosecutor, every judge, every member of Congress up at night is whether anyone in this network will ever face real federal accountability. Because the documents that exist, the ones we've seen, they show a network. They show connections. They show a pattern of conduct spanning decades in multiple countries. But a network requires prosecution, and prosecution requires political will. And right now, political will is the one thing this case has consistently lacked. Here's where we are. 3 million pages are out.
500,000 have been uploaded to the DOJ website with no index, no table of contents, no explanation of how any single document fits into the broader investigation. The Oversight Committee is demanding the rest. Lawmakers on both sides have questions and the public is watching. But watching isn't enough. The Epstein case exposed something that goes far beyond one man. It exposed a system where wealth, political connection, and institutional deference allowed decades of criminal conduct to continue with minimal consequences. The sweetheart deal, the sealed agreement, the dead defendant, the withheld documents, every single one of these was a choice made by people with the authority to act differently. And the victims, the girls and young women who were abused, they paid the price for every one of those choices. So, as this investigation continues, and it will continue, the most important thing you can do is stay informed, demand answers from your representatives, and hold every institution in this chain accountable for what they knew and when they knew it. More accountability, more truth. This story is not over. https www.youtube.com. Watch via MQQC PAU 0